Good evening to the participants of the JCJ 2022, the main examination. I believe that still the date is not given. If the date is given, please post me and read what I posted on the screen. Anyone can unmute and read what I posted on the screen. Participants. Okay, let me read it. Welcome to the online class to the aspirants of the JCJ 2022 main examination. And here the difference between the are among the license, lease, and easement. If the 2 is there, we can say the difference between. If the more than 2 is there, then difference among the 3. So here the license and lease and easement, and today that I would like to wind up this easement chapter. So now in my last class I was in this place. Here I put the asterisk mark. And this asterisk mark showed that I completed up to this extent. So now let us see the irrevocable licenses. When you see the section 60 provides that the license can also be revocable. If the license is coupled with the transfer of property and the transfer is in force, it cannot be revoked. If once the license will be given, in certain cases it cannot be revoked. This is subject to the agreement. Hence, the power can be reserved. The rule is that a bare license may be revoked, but if coupled with the transfer of the property, then it is irrevocable. If the bare license would be there, it can be revoked, but if the coupled with some sanctions or conditions, then it cannot be revoked. And that is the irrevocable license. Now let us see one example. A license coupled with an interest in the land in binding. A license coupled with the profit, a pendere is irrevocable. Suppose the profit pendere is there, and where he is going to get the benefit, it cannot be revocable. It cannot be revocable. Means it is irrevocable. For example, right to excavate earth and carry it to make earthenwares, right to cut and carry the timber on payment of royalty. In such a right is irrevocable because they are going to get the benefit. And here, the excavation of the earth, the earth, what is sand? I don't say sand. It is I don't say the mud. Also, it is, but the earth material, and that can be used for the earthenwares. And the right to cut. When you give the right to cut the timber, that means you are cutting not for the sake of only the cutting, but the sake of the carrying the log and selling it, and the payment of the royalty, when the paying the royalty payment. So that is the way that we can make it out. Now let us see if the licensee has executed some work which is a permanent in nature and has incurred expenses, the license cannot be revoked and hence it is irrevocable. When you are getting the license and which is in a permanent nature, and for that regard there is incurred some expenses, like license will be given for the light motor vehicle and heavy motor vehicle, and once it is given on the payment of it for a particular period, it cannot be revoked unless until you violate it. It can be seized and it can be penalized and it can be sent to the court. For example, there are two companies, namely X and Y, having land adjoining to each other. There is the X company and the Y company. They are adjacent together. The agents were common who managed to put up the building and tank on X land for use by Y. So the agents are common and managed to put the building and tank. There is a building and a tank on X land for use by Y. Of course, when the tank would be there, that water could be used by the Y also. License is irrevocable as the rule applied. It was held in Ramsden versus Dyson. Suppose if he is using the water from the X land, who is Y company at the time, it is a permanent form and it is irrevocable. And that is observed in the case of the Ramsden versus Dyson case law. Now let us see the tabular difference between the license and easement. Later on we can see the license, easement and lease. Is it clear? Participant, are you hearing us? Say yes. So license, and in the left hand side is a license, the right hand side is an easement. In the left hand side, the license, number 1, a license is a form of a personal right attached to an immobile property. I already discussed earlier, the license will be given for only the enjoyment of the immobile property. And when you come to the easement is concerned, a right of easement is a right appertinent to immobile property. Yes, this is also immobile property. Like in the last class, I shown that apartment, the easement of apartment, where the servient heritage is binding on to use his land by the dominant heritage. Is it clear? Participants, please give the answer. And the second point is, it is a right in personam, because it is in particular person, the license will be given. When it matter comes to it is a right in rem. Easement is a right in rem against the whole world. Then the third point is this right cannot be attached. The license cannot be attached. But when you come to the easement, it is a right which can be annexed to the property which is attached. It is attached to the land. Because when you sell the land, automatically, when the sale annex, the attachment is there, annexed would be there. The right of easement also goes to the purchaser. Is it clear? Yes. Next is license is revocable. Here, on the situation, the license can be revocable, and easement are not revocable at all, because once the easement is given, it is forever. The fifth is it is a permission given by the licensor. There is a grantor. Here, the grantor gives the license and grant the license, and this easement is acquired as of a right. By the operation of law, a right can be accrued over there, existence over there, a right can be enjoyed over there, and right will be passed to the purchaser when the land is. Because the land, when you enjoy the land of your own, at the time you need the path, and the right to path is annexed to the land, and it will be go with the property when it comes to the transferred. So, participants, you are very silent today. Now let us see the conclusion of this easement. Later on, we'll see the differences among the lease, easement, and license. So today that I would like to wind up this chapter of the easement. The Indian Easement Act provides for the whole concept of right of easements and its regulation in India. How the easement will be applicable to the servient heritage by the dominant heritage, it will be clearly given in the Act. In India, easement as defined under the Section 4 of the Act is a right enjoyed by the owner of the dominant heritage over the heritage of the servant. So, dominant heritage will enjoy over the heritage of the servant owner for the beneficial enjoyment of his own land. If his own land that he want to enjoy, he should have to use the easement of the servant owner. It is only defines what actually easement consists of, but also provides with its clarification. Easement can be prescriptive, and we have seen the different type of the easement. This is a prescriptive, customary, quasi, and necessity. And we also seen the mode of acquiring the easement, and we studied in the earlier classes. Therefore, the modes of acquiring easement has been provided under Section 7. What is easement, which is given in the Section 4? The mode of acquiring the easement is given in the Section 7 of the said Act, according to which it can be acquired through an express grant or implied activity, or in certain circumstances considered to be an implied right, both the express as well as implied right. If easement is to be acquired through the express grant, then such a clause has to be specifically mentioned in the deed of the sale. It should be the expressly given over there, then the wording should be there in the agreement or in the deed. The deed of sale or the mortgage or lease, by way the property will be transferred, or any other deed in accordance with the mode of transfer. The easement is a right in rem, and we discussed, but the license is not right in rem, it is a right in personam in a particular person. That is, it is available against the whole world. Which one? Easement. It can be subject to the limitation as well as can be restricted to. Easement with the subject to restriction, either happening of a certain event, not happening of a certain event, or condition should be fulfilled, or condition will not be fulfilled. Based on that, the easement could be exist and it can be enjoyed. Easement can be both positive and negative. Positive to do a particular thing, negative not to do a particular thing. Whereas on the other hand, license can only be a positive in nature. License is not a negative in nature, it's only the positive. For instance, you are given the license to drive, only positive license. If you are not qualified to get the license, then you will be disqualified and you will not be given the license unless until you fulfill the condition. Like one of the conditions for getting the license is you should be more than 18 years. Is it clear? Say yes. So, further, the Act talks about the provisions regulating the suspicion, and it is about the suspicion would be there when we want to take it about the provision regulating the suspension, even suspension, termination, or extinction, and we studied it. Extinction or revival of the easement, these are all the things that we'll study in the easement. So also how a easement is different from the license. We have seen license distinction and the easement distinction. Yes, Gausia, could you tell me which is right in rhyme, which is right in personam? Are you hearing me, Gausia? Easement is right in rhyme or right in personam? The breaking of the voice.
Right in rem is against whole world, sir.
Is it for the easement or is it for the license?
It is for easement, sir.
Okay. Then what about the license?
License is only a permission given to enjoy the particular thing, sir.
Means right in? Right in?
Personam, sir.
Very good, very good. So this article also explains the concept of license along with its essentials. License can be revocable as mentioned in the Act and irrevocable also as mentioned under the Section 60 of the Act. They can also be transferred according to the Section 56 of the Act, and it is right in personam, which is not available against the whole world but is granted personally. So these are the things that we have studied it. Now let us see what would be the distinction among the license, lease, and easement. Difference, we don't say between. What do you have to say? If you know it, you tell me. If you don't know it, you say pass on.
Among, sir.
It is among. When the more than two is there, we should say among. If the two is there, then we can say the difference between the license and lease. But here, between should not be used over there. It should be more better to say among. Difference among license, lease, and here
Easement.
and should be there, and easement.
Yeah.
So let us see the terms, definition of a term. Which term? Yeah, license. As we discussed as per the section 52 of the Indian Easement Act 1882, I quote, where one person grants to another or to definite number of other persons are a right to do or continue to do or are in or upon the immovable property of the grantor something which would, in the absence of such a right, be unlawful, and such a right does not amount to an easement or an interest in the property, the right is called license. I unquote. So that is the section 52 spells regarding the license. Now let us see the lease. And the lease is, as per the section 105 of the Transfer of Property Act 1882, a lease of immovable property is the transfer of a right to enjoy such a property made for a certain time, express or implied, or in perpetuity, in consideration of the price paid or promised, or of money or promised to pay a share of crafts, services, or any other things of value to be rendered periodically on a specified occasion to the transferor by the transferee who accept the transfer on such terms and conditions. Lesser lessee, premium and rent, they are defined. The transferor is called the lessor and the transfer is called the
Lessee.
lessee. The price is called the
Premium.
and the money or share or services or other things to be so rendered is called rent. So these are the way we can make it out, which is called the premium and which is called the money, share, services, or any other to be rendered is called a rent. So premium is different, rent is different. Am I right?
Yes, sir.
Where do you make the premium? Where do you pay the premium or installments?
A large amount is paid for a certain period at a time. Then it is
Example? Example? Oh, power is gone. Okay, I think I have an inverter in our house. Yeah, power has resumed. Example is premium you will pay for the insurance.
Yes, sir.
Am I right?
Yes. For a immovable property, also they'll pay for 1 year, sir. That may be mortgage, sir. They'll pay for 1 year, and after that, they won't pay for as rent, sir. Monthly payments they will not do.
Yeah,
They'll
yeah,
give
yeah.
a
It is a lump sum to be paid quarterly or half yearly or annually.
yes, sir.
So, easement, as per the Section 4 of the Indian Easement Act 1882, easement define an easement is a right which the owner or the occupier of certain land possesses. पूरे off कर दो इधर, खाली एक रखो. Yes, as such for the beneficial enjoyment of that land to do or continue to do something or to prevent and continue to prevent something being done or in or upon in respect of the certain other land not his own. Are you hearing me?
Yes, sir.
Okay. The dominant and servant heritage and owner. The land for the beneficial enjoyment for which the right exists is called the dominant heritage, and the owner or occupier thereof, the dominant owner, the land on which the liability is imposed is called the
Leasehold property.
servant heritage. I am speaking to the dominant owner,
Okay, sir.
and the dominant owner who is bearing servant heritage, and the owner of the occupier thereof, the servant owner. Either you can say servant owner or you can say servant heritage. Now let us see the difference among the license, lease, and easement, how it can be made. Section 52 of the Act interpreted as it can be said that when a person is given the right to use particular property for a certain use, while the possession and control of the property are with the owner, the person will be considered as a licensee. A license can be granted only to a definite number of the people, as a license is a personal right given to the licensee. But the ownership will not be given. Only enjoyment of the certain premises will be given to him. It is nothing. It is nothing but a certain in which a property owner lets an individual or an entity like a company, government, or a school use a real property for a specific purposes. Usually, licenses are personal to the licensee, the individual or entity, or if the licensee attempts to transfer it, license usually terminate. They are typically revocable and may be exclusively of non-exclusiveness. So, a license cannot be transferred. Am I right?
Yes, sir.
Then the essential of the license are as follows. A license does not create an interest in the property. It acts only as a permission which created a personal right with regard to the property. You are not the owner of the property. You can only enjoy the premises for a certain time. A license authorizes certain acts on the property which would be otherwise unlawful. For instance, you purchase the ticket for enjoying the movie. How many shows are there in the theater?
4, sir.
What are they?
Morning show, of matinee, uh, evening show, and second show, sir.
Morning show, matinee, first show, and second show.
Okay.
In the Sankrantri, there is a Jagaram is there. Which place there is a Jagaram? In which festival?
Sivaratri, sir.
Yeah, there is a midnight show also there. Am I right?
I don't know, sir.
You don't know. So there are total 5 shows are there in Shivaratri. What are they? Morning show, matinee show, first show, second show, midnight show. Is it clear?
Yes, sir.
Okay, number 3, a license can be assigned or transferred to some third party. It cannot be assigned or transferred to some third party. Am I right?
Yes, sir.
Suppose if you got a license for a motor vehicle with a gear and light motor vehicle, that cannot be transferred to you, either to your brother or husband or anybody. Am I right?
Yes, sir.
Good. Lease. Section 105 of the Transfer of Property Act 1882 states that a lease which states that it is a transfer of the immovable property for a particular time period for a consideration which the transferee has accepted terms surrounding the agreement. The terms and conditions will be for the lease. The lease is for the movable property or immovable property?
Immovable property, sir.
Then what do you say the movable property?
Rent, sir.
Not. Suppose you want to keep your wristwatch to get the money from a broker.
That is pawn, sir. Pledge or pawn.
PAWN, pawn. So it is a contract where a landlord agrees to give a tenant the exclusive right to inhabit or occupy the real property, such a house or apartment or office. A lease usually has a specific term, and like all contracts, the tenant is going to give the landlord some sort of the consideration, money or etc. Even horses also, some services also. So one of the mode of transferring property for a particular period of time is a lease. A lease is a transfer of an interest in the property for a stipulated period for time being without transferring the ownership of that property. In a lease, right of possession is transferred instead of the right of ownership. What would be transferred in the lease?
Possession, sir.
It is only the possession will be transferred, but the right of the ownership lies with the owner.
Yes, sir.
What about in the mortgage?
Mortgage also same thing, sir. Possession will be transferred and ownership will be with the owner.
In some mortgages, even the ownership also be transferred. Kinds of a mortgage you studied. Okay, let us see the transfer here is called the lesser and transfer is called enjoying the property for a period is called lessee. Is it clear? Say yes. Is it clear? Participants, is it clear? I could not get the voice. Even I could not see your microphone. Okay, essential of lease are as follows. Number one, the parties in a lease agreement should be competent to enter into a contract because it's a contract. Whatever the conditions would be there for the contract, the same conditions would be applicable in the lease. Okay, number two, the ownership. The ownership rights are not transferred in lease. Only the possession of the property is transferred, just we discussed before. Number three, consideration. For a lease can be taken in the form of a rent or premium, both the way. And the fourth, lessee who is get the interest of the property after lease has to accept the lease agreement along with the time period and the terms and conditions imposed on the transfer. So it is self-explanatory. It doesn't need any explanation at all. The five, lease always takes place for a particular time period, which is to be specified in the lease agreement. It can be relaxed at the option of the lessor. Then who is having the high bottom line? Lessor. Who is having the low bottom line? Lessee. Is it clear? Now let us go to the easement. How the easement would be there. When a person is having a right over the land of another for the enjoyment for his own property, the right over the property of another is called easement. He enjoys the property, even though the property doesn't belong to him. To enjoy his own property, he has to use the property of somebody else. And hence we can say dominant heritage and servient heritage. The essential of the easement are as follows. Number one, for easement, there is a necessity of two parties, that is a dominant and servient heritage. A dominant heritage means that the land for the whose beneficial enjoyment right are exercised. Servient heritage means that the land on which liabilities are imposed. Dominant and servient heritage must be separate. Number two, right over the immovable property. Yes, for the immovable property only this dominant heritage and servient heritage will come. The two parties should be exist over there. Number three, two separate properties. Of course, they do have their separate property. Dominant heritage having separate property and servient heritage is having separate property. Not. When the two properties become one, automatically ease will be extinguished. Am I right? Participant. I could not get the answer from you. Number 4, easement must be attached with the property. Yes, when you sell the property, automatically the easement also annexed to the property and it's go to the buyer. Number 5, easements are ordinarily available against the entire world. This is the right in rem, and hence they are considered the right in rem, what we discussed. But when you say the license, it is the right in personam, means a particular person. And 6, the easement must be for the beneficial use of the property, definitely. Even the license also, it is a beneficial of the movable property he could enjoy for the time period. 7, it is necessary that the dominant and servant heritage must be separate. Yes, if they are not separate, and if they are not separate property, if the property becomes one, and automatically the easement will be extinguished or terminated or seized. Illustration: A has the owner of certain house, has a right to go on his neighbor B's land. Without using the B's land, he cannot enjoy his A's property, and to take the water purposes for his house, to fetch the water, to get the water from the B's land out of a spring there. If there is a fountain and there is a well, and this is an easement. A dictates to the public the right to occupy the surface of certain land for the purpose of passing and repassing. The right is not an easement. Suppose somebody has used the land and give the permission to use it, only surface of the land. It doesn't mean that it is a easement. That's why we can see a notice. A notice will be there. What is the notice? Caution notice. Idi rahadari kaadu. Say in English. Idi rahadari kaadu. That means it is not a thoroughfare. So that is its English translation. Trespasser will be prosecuted. Even that also be written over there. If the right to use the property will belong solely and exclusively to the user, even against the property owner, and you have a landlord and tenant arrangement or lease improper, if the user or the occupancy of the property will be shared by more than one person or entity, then a licensee of an easement is proper. If the use is long term, like a sewer, cable, flower garden, or access to road, or easement is the way to go. It is a permanent and the long way to go. So these are the things which I want to share. And still, video has the time with us, but yes, the time is with us, but the chapter is over, and I would like to close. Or do you want to ask any questions? Yes, anybody wants to ask any questions, you can ask me. Because in the easement, we have seen how the easement will work. Easement, let me make it out, still the time is there. So let me make it out. Easement videos. Let me see the any videos are there. Easement videos. Yes, it is there, but I don't know whether it is in English or what are the embrace the real state of the grants of another. It's an easement. And what is an easement under an easement act? YouTube is there. Okay, let me see the first one, whether it is English or not. If it is English is there, then I can play it and you can hear it, because still the time is left over to left.
Listen, raise your hand if you don't have confidence in your English speaking skills.
Yeah.
Hello, everybody. Thank you for coming to this week's video blog here at California Realty Training. We are so anxious to get more stuff out to you, but you got to watch. And you know what? Tell your friends to watch this stuff. If you know anybody who's getting into
this English is very tough. Better we go for the next video. Oh, this is the Urdu video. And yes, this is the Urdu video. Next, we go to the another property video, the Prof. Dale instruction to the easement, whether he says in English or whether he says in other language. I think he is also Professor at Emeritus. He is. Participants.
Prof. Dale's Property Video number 34. I'm your host, Dale Whitman. In this video, we're going to cover an introduction to the law of easements.
Let us see that we will make it out, this video. Okay, let me share this first one so that you could see it. I want to make it share, then I will say share content, then share computer audio, then I will play it. Okay, now enjoy it.
Hello and welcome to Prof. Dale's Property Video number 34. I'm your host, Dale Whitman. In this video, we're going to cover an introduction to the law of easements. So what is an easement anyway? Well, an easement is a legal right to make a limited use of another person's land for some specific purpose. Easements are very, very common. They're commonly used for things like streets, roads, and driveways, for electric, water, sewer, and other utility lines, for recreational activities, and for the flowage of watercourses. Those are all typical easements. Now, how's an easement different from an estate? Well, estates give possession, and the word possession means that a person with possession can basically use the property in any way they wish. They can damage it, they could even destroy improvements on it, they could build things on it, they can do whatever they like, as long as, of course, they don't violate the local zoning ordinances or the law of nuisance. Easements, on the other hand, don't give possession. They give only a limited right of use, and the key there is limited. Easements don't give you the right to do anything you want to on someone else's land, but only some limited and specific activity. So why does it matter whether someone has an easement or an estate? Both of them give you the right to go on the land. But it turns out that estates are much more valuable, much more useful, and much more flexible than easements are. Let's look at some of the reasons why this is true. Suppose there is a parcel of land and there are minerals or oil or gas on the land. If you have an estate, you're entitled to those minerals or oil and gas unless they've previously been severed from the surface estate. But with an easement, you don't get any minerals or oil and gas at all. You just get the right to make the limited use of the property that the easement grants to you. Similarly, with air rights. If you have an estate, your air rights are basically unlimited. You can build as high as you want to, subject, of course, to the local zoning ordinance. On the other hand, if you have an easement, your air rights are limited. You can only use the amount of airspace that's necessary to give proper enjoyment to the easement itself. If I gave you an easement for driving trucks, for example, your easement would probably be limited to about 14 or 15 feet in height because that's all the airspace that the trucks would reasonably need in order to use the driveway. Another difference lies in whether use restrictive scope language in the grant is binding or not. If you have an easement, then use restrictive scope language, language that says what the easement is for, is highly significant and completely binding. On the other hand, if I gave you an estate and I put in some use restrictive scope language, I said something like, I'm giving you this estate for driving and parking trucks, well, you wouldn't be bound by that at all, and you could use the estate for any other purpose that you wished. So use restrictive scope language is critical to easements, but totally insignificant when it comes to estates. The exclusivity of the holder's rights is another difference between easements and estates. Estates are always exclusive. If you own an estate, you can always exclude other people from it. But easements may or may not be exclusive. Some easements are exclusive and some are not. We have to look at the way the easement was created to find out whether it's exclusive or not. It might be that you have the right to use an easement, but other people could be using it simultaneously. If the property is condemned, that is, if it's taken by a government body in eminent domain, then do you get compensation? Well, estates always get compensation if they're taken by the government. And easement holders are also entitled to compensation if their easements are taken, but estates are generally more valuable than easements, and they're generally entitled to greater compensation. Finally, can you abandon an easement or an estate, and if you did, would that lead to the loss of ownership? Well, here, easements and estates are completely different. Easements can be terminated by abandonment. You can lose an easement if you don't use it, but estates cannot be. If you own an estate, even though you don't use it, you don't possess it, you don't even go anywhere near it, your ownership will continue indefinitely. Now, here's an interesting question, one that you'll sometimes see in judicial decisions. They will say, the issue in this case is, did the grantee receive an easement or a fee simple? Well, what's wrong with that question? It's a completely nonsensical question, and yet it gets asked all the time. The reason it's nonsensical is that both easements and estates can be, and usually are, in fee simple. The term fee simple simply implies that the estate or easement will continue indefinitely, and both easements and estates generally do continue indefinitely, and therefore it's perfectly proper to talk about either an easement or an estate as being in fee simple. The real issue in these cases is usually this: is this an easement or is it an estate? So when you're talking about easements, be sure to distinguish them from estates, not from fee simple. Now, of course, an easement doesn't have to be in fee simple. We presume that an easement's in fee simple, just as we do with an estate, if nothing to the contrary is stated. However, if we read the grant, we might find that an easement is intended to last for less than indefinitely. For example, it might be in fee simple defeasible. You'll remember fee simple defeasibles when we talked about estates. Well, easements can be in fee simple defeasible as well. Here's an example. We might say, we grant this land to the railroad for use as a train, so long as the track is used at least once each month. I actually once had a case in which that was almost exactly the language used, and it became an easement in fee simple determinable, because it would terminate if the use of the track wasn't made at least once a month. An easement might be for someone's life. I could grant you not a life estate, but a life easement. I could grant you an easement for a fixed term, for 5 years or 1 month or 20 years. I could grant you an easement, in fact, for any other duration for which an estate can be limited. So all the ways that we can cut short the life of an estate, we can cut short the life of an easement in exactly the same ways. Now, we're going to spend a few minutes at this point discussing the difference between easements and licenses. Both an easement and a license give someone a legal right to be on somebody else's land. But an easement is a real property interest. That is, it's an interest in land. It's a property right. A license, on the other hand, is not a property interest. It's simply permission to be on somebody else's land. And if you think about it, you'll realize that we all have licenses all the time. Almost everyone has some licenses every day. We usually don't even think about the fact that they are licenses. Now, licenses are extremely common, but they're usually brief and rather ephemeral. For example, if we shop at a store, the store puts an open sign on its door or just opens for business and invites us in. And so we have permission to be in the store, and so it's a license. It's the right to be on somebody else's land with their permission. The same is true if we go to the movies. We have a license to sit in the theater. If we go to a sporting event, we have a license to sit in the stands and watch the game. If we eat at a restaurant, we have a license to be there. If we park our car in a parking lot, we probably have a license, although there's a possibility that we also have a bailment of the car, particularly if we turn over the keys to a parking lot attendant. But in any event, we do have a license to be on the lot. If we visit a friend's house or a friend's apartment, we have a license to be there. So you can see that licenses are extremely common, and they don't require any particular formality, just an invitation to come on someone else's land. Now, some licenses are formalized in writing, and some of them last for a longer term. Here are a couple of examples.
Jai Hind.